You're tuned into The Deep Dive. Today, we're tackling something that can be really stressful, dealing with debt collectors.
Yeah, those calls, the letters, it can feel pretty overwhelming.
Definitely. And if you've ever felt, kind of cornered or just confused about your rights when a debt collector contacts you, well, you're in the right place.
We're going to cut through some of that noise today.
We are. We're doing a deep dive into the rules, specifically focusing on one key piece of legislation.
That's right. We're looking at the Fair Debt Collection Practices Act, usually just called the FDCPA.
The FDCPA. Okay.
Right.
Think of it as your guidebook, maybe, your shield.
Exactly. A shield is a good way to put it. It's designed to protect you from unfair tactics used specifically by debt collection agencies.
So the FDCPA, let's break that down. At its core, what's this law actually doing for people?
Well, it's a federal law, passed way back in '77, actually. And its main purpose is to set clear boundaries for how third-party debt collectors can behave.
Third party. Okay, let's clarify that.
Yeah, it's crucial. The law primarily targets these separate companies, the collection agencies, that are hired by, say, a credit card company or a hospital to collect a debt for them.
Right. So it's not usually the original company you took out the loan with or whose bill it was originally?
Generally, no. If
Yeah.
you're dealing directly with the original creditor, the FDCPA might not apply in the same way. There are other rules, but the FDCPA really kicks in when that debt gets passed along or sold to a collection agency.
Got it. So that's our focus, your rights when you're hearing from one of those agencies.
Precisely. We want listeners to walk away knowing what these collectors can, and just as importantly, cannot do. Actionable knowledge.
All right, let's get into the nitty-gritty then. What are some of the big rules about how and when they can even contact you?
Okay, well, one of the first things the FDCPA tackles is timing. They can't just call you whenever they feel like it.
Makes sense. There have to be some limits.
There are. Legally, they're restricted from calling you before 8:00 in the morning
Okay.
or after 9:00 at night, and that's based on your local time zone.
Right, so no super early wake-up calls or late-night interruption.
Exactly. It's about respecting your time and, frankly, your peace.
What about at work? Getting those calls at your job can be, well, problematic.
Absolutely. And the FDCPA covers that too. If you tell a debt collector clearly that you aren't allowed to get calls at work or that it's inconvenient,
You just have to tell them.
you tell them, and they must stop calling you there. It's your right to keep your work life separate from this. If they keep calling after you've told them not to,
That's a violation.
that's a clear violation. Plain and simple. They have to respect that boundary.
Okay, so time limits, no calls at work if you object.
Yeah.
What about the way they talk to you? You hear stories about collectors being really aggressive.
Yeah, and the law is very clear on this. Harassment and abuse are prohibited. Full stop.
What counts as harassment under the law?
Well, things like shouting, using obscene or profane language, calling you over and over again just to annoy you or wear you down, that kind of conduct is illegal.
So basically, intimidation tactics are out.
They should be. The idea is professionalism, not bullying. They also can't threaten violence or harm, obviously.
And it's not just about tone or threats, right? What about just lying, making things up?
You're spot on. Deceptive practices are also strictly forbidden by the FDCPA. They can't misrepresent who they are.
Like pretending to be someone they're not?
Exactly. They can't claim to be law enforcement, for example, or impersonate an attorney if they aren't one. Using false pretenses to scare you is illegal.
No fake badges, no phony legal letterheads.
None of that. And this ban on misrepresentation, it extends to the details of the debt itself, too.
Okay, so what kind of lies about the actual debt are off limits?
Well, for starters, they cannot lie about the amount you owe. They have to state the correct current balance. Inflating the amount is a violation.
Gotcha. What else?
They also can't make false threats about the consequences of not paying. Like they can't threaten to have you arrested if that's not legally possible for that type of debt.
Which it usually isn't for consumer debt, right?
Yeah, correct. Debtors' prisons are not a thing in the U.S. They also can't threaten to take specific legal actions, like seizing property, unless they actually have the legal right and the intention to do so. No empty threats allowed.
Okay, so honesty is required about who they are, the amount owed, and what could really happen.
That's the standard the law sets.
Now, something else that comes up a lot is this initial written notice. What's that about? Sounds important.
It is very important. It's a key protection. Within 5 days of the first time a debt collector contacts you, could be a call, could be a letter, They are legally required to send you a written notice.
Within 5 days of that first contact?
Yep. And this notice isn't just a hello. It has to contain specific, crucial pieces of information.
Okay, like what should people look for on that notice?
It absolutely must state the amount of the debt they claim you owe.
Okay.
It must name the original creditor, the company the debt was originally owed
Good.
to.
Right, so you know where it came from.
Exactly. And critically, it has to include a statement explaining your rights. Specifically, your right to dispute the debt.
Ah, the dispute, right. How does that work?
The notice has to tell you that you have 30 days from the date you receive it to send a written request disputing the validity of the debt or asking for verification.
So you get 30 days to say, hold on, I need proof this is mine, basically.
Pretty much. And if you send that written dispute within those 30 days, this is key.
What happens?
The debt collector must cease all collection activity on the debt. They have to stop trying to collect until they obtain verification of the debt and mail it to you.
Wow, okay. So sending that letter really puts the brakes on things.
It does. It forces them to pause and prove the debt is accurate and belongs to you. The verification might be, say, a copy of the bill or the signed contract that created the debt.
And if they don't send that initial notice with all that info, or if they keep collecting after you disputed it but before sending proof,
then they're violating the FDCPA. Both the notice requirement and the debt validation process are fundamental rights you have. They're there to prevent you from being pressured into paying debts that might be wrong or not even yours.
Okay, that validation process sounds like a really powerful tool.
It really is. Don't underestimate it.
All right, so we've covered time limits, work calls, no harassment or lies, and this critical validation right. What if someone just wants the calls and letters to stop entirely? Is that possible?
Yes, it is. The FDCPA gives you another very strong right. The right to tell a debt collector, in writing, to stop contacting you altogether.
Just stop completely.
Essentially, yes. It's often called a cease and desist request, though you don't need to use fancy legal terms. Just a clear written statement saying you want them to stop contacting you.
And they have to honor that.
Once they receive your written request, they are legally barred from contacting you further, with very limited exceptions.
What are the exceptions? Can they still call sometimes?
No, generally no more calls or letters trying to collect. The main exceptions are they can contact you one last time to tell you there will be no further contact.
Okay.
Or they can contact you to notify you that the collector or the creditor intends to take a specific action, like filing a lawsuit.
But that's it. No more general collection calls or demands for payment.
Correct. Beyond those very specific limited communications, they have to respect your written request to cease communication. It's a way to regain control if the contact feels overwhelming.
That sounds like a huge weight off someone's shoulders if they're being bombarded.
It absolutely can be.
Okay, let's quickly recap the big rights here. We've got no calls super early or late.
Right. 8 a.m. to 9 p.m. limit.
Tell them no calls at work and they have to stop.
Yeah, if you tell them.
No harassment, no abuse, no lies about the debt or consequences.
Crucial. Honesty is required.
You have a right to that initial written notice within 5 days, detailing the debt and your dispute rights.
And that 30-day window to demand validation.
Right, and if you demand validation in writing, they have to pause collection until they provide proof.
A very powerful tool.
And finally, you can send a written request for them to stop all communication with only a couple of narrow exceptions.
That's the core set of protections under the FDCPA when dealing with third-party collectors.
It's actually quite a lot of protection when you lay it all out.
It is. The law recognizes the potential for abuse in this area and tries to create a fairer process.
Okay, so the unfortunate reality is sometimes collectors do break these rules. Let's say someone listening has experienced this. What should they do? What are their options?
That's a really important question. Knowing your rights is step one. Knowing what to do if they're violated is step two. You definitely have recourse.
Where should they start?
A really good first step is to report the violation. One key agency is the Consumer Financial Protection Bureau, the CFPB.
The CFPB.
Yes. They were specifically created after the financial crisis to protect consumers in financial matters. And they handle complaints about debt collection practices. You can file a complaint online.
Okay, so CFPB is one place. Anywhere else?
Absolutely. You can also report the collector to the Federal Trade Commission, the FTC. They've historically been involved in enforcing the FDCPA and tracking problematic collectors.
FTC, got it.
And don't forget your state authorities. Filing a complaint with your state's attorney general is often a very good idea too. Many AG offices have dedicated consumer protection divisions that can investigate and sometimes take action.
So CFPB, FTC, and state attorney general. Reporting seems like a key step.
It helps regulators track patterns of abuse and can sometimes lead to enforcement actions against bad actors. Plus, it creates a record of your complaint.
Does it stop there, or can an individual take legal action themselves?
You absolutely can. The FDCPA specifically gives consumers a private right of action. This means you can sue a debt collector in federal or state court if they violate the law.
You can actually sue them.
Yes. Generally, you have 1 year from the date the violation occurred to file the lawsuit.
And what can you potentially get if you win that lawsuit?
If the court finds the collector violated the FDCPA, you can recover any actual damages you suffered because of their illegal actions. Maybe lost wages if calls got you fired, or emotional distress damages in some cases.
Actual damages.
Okay. Plus, even if you didn't suffer specific monetary damages, the law allows for statutory damages up to $1,000 per lawsuit.
So even without proving financial harm, there's a potential penalty.
Exactly. And maybe most importantly, if you win, the court can order the debt collector to pay your reasonable attorney's fees and court costs.
That's huge, because hiring a lawyer can be expensive.
It is. This provision makes it much more feasible for consumers to actually pursue their rights in court because lawyers might take the case knowing their fees could be covered if they win.
So there are real teeth to this law, reporting options and the ability to sue with potential damages and attorney fees.
Definitely. These aren't just suggestions. They are legal requirements with real consequences for collectors who ignore them.
That's incredibly important for people to understand. You're not powerless here.
Not at all.
So, wrapping this up, I think the core message, the big takeaway from our deep dive today is pretty clear.
Yeah. What stands out most to you?
Just that. Being in debt, facing financial challenges, it absolutely does not mean you forfeit your basic rights or your dignity when a collector calls.
That's perfectly put. The FDCPA exists to ensure you're treated fairly and lawfully, regardless of your debt situation. Knowledge of these rights is power.
It really is. Knowing you can demand verification, knowing you can stop the calls, knowing harassment is illegal, that changes the dynamic, doesn't it?
It should empower you to assert yourself and push back against improper conduct.
So maybe a final thought for everyone listening. Take a moment and consider, now that you know more about these protections under the FDCPA, how might this change how you handle things if you do get contacted by a debt collector in the future?
Yeah, how does knowing your power shift your perspective or your potential actions? Something to reflect on.
If this podcast helped you, don't forget to like, comment, and subscribe. Your support helps us keep making these videos. Thanks for watching.